compensation and C-note leave. Under Puerto Rico law, worker compensation is government sponsored, and you need, among the things, and I believe it was in one of the previous presenter slides, that you need to make sure is that you enroll with the Puerto Rico el Fondo del Seguro del Estado, the state insurance fund. That is the provider of workers' compensation leave and benefits. And if an employee suffers an injury in the workplace, you need to make sure that you refer them to the state insurance fund, and they're going to take care of treating them and during whatever period of time that injury will preclude them from returning to work. This is pretty straightforward. There's not much room for questioning the decisions from the state insurance fund. You just need to make sure that you fill out the paperwork and you remain on top of when is the employer going to return to work. There are two kinds of treatment options. The employer can be put on rest or can return to be returned to work while receiving treatment. These are form notifications that you will get from the state insurance fund. During the period of time that the employee is receiving treatment from the state insurance fund, he is protected by the statute from any kind of retaliation for precisely that treatment. And when the state insurance fund releases them to return to work, you must bring a statement to the same position that they occupied before the leave. This is also the case with non-occupational disability leave. Under Puerto Rico law, that can be state-sponsored, or you can decide to provide coverage through a private insurer, but the requirements of reinstatement are still the same. This throws a monkey wrench on most systems that work in the United States in terms of FMLA leave and leaves of absence. You just need to take into consideration when you're evaluating the need for leave that there are these two additional provisions that you need to be able to provide to the employees the necessary documentation so that they use their rights and that you are ready to reserve their jobs and reinstatement when you receive the appropriate notification. Otherwise, you will see, again, you can face a cause of action, you can face reinstatement orders and damages, which are doubled under the statute. Okay. The next slide is Puerto Rico Act 44, which is basically the same as the American with Disabilities Act. It's a parallel statute, merely that it provides, again, for double damages. If there is no compliance, it prohibits discrimination on the basis of disability, and it establishes an obligation to consider reasonable accommodations. But at this juncture, if you're used to handling ADA stateside, it's basically, it transfers exactly the same to Puerto Rico. You just need to make sure that you have the procedures in place to be able to address any request or any need for accommodation. And you have, when you see the presentation, you will see some slides that will give some additional background information on this. Okay, the one thing I wanted to address with you is precisely the interplay that you will see maybe in the case of an employee who is under treatment in the state insurance fund and all of a sudden shows up to work with a release from that agency, but also a letter from the state insurance fund saying you should provide this employee reasonable accommodation. The state insurance fund does not handle reasonable accommodations and has no authority to force an employee to provide any given accommodation. When you receive such a communication from the state insurance fund, you should simply treat it as any other medical certificate that you might receive from an employee saying, you know, this employee has these limitations and you need to consider reasonable accommodation. You don't need to provide exactly what the state insurance fund is recommending. You simply need to enter into the interactive process to evaluate what is reasonable and what can in fact be done. But it does not mean that you need to do whatever the state insurance fund tells you to do, because that agency's responsibility is merely to treat the employee, pay whatever amounts they need to be paid during that leave, and release them to work. But they do sometimes overextend themselves in making these kinds of recommendations. A summary procedure for labor and employment claims. This is something that trips a lot of employers up. Under Puerto Rico law, any employment lawsuit that is filed in the state courts can be filed under summary proceedings. It imposes strict conditions and limitations regarding a reduced time to answer. Basically, once you are served with process, the employer has 10 calendar days to answer that complaint. And if it is not answered within those 10 days, default judgment can be entered. So you will have no alternative to defend against the allegations of liability. You will only be able to defend against the issue of damages. It applies to all labor and employment claims. There are some technical issues that must be complied with in terms of the service of process, but it is very important that you are ready to address these claims expediently, and that you're able to forward to your attorney or whomever is going to take care of answering these claims as quickly as possible, so that you do not end up facing a default judgment. There are 15 days if the summons is served in a different judicial district. For example, if your base of operations is in San Juan, but the lawsuit is filed in Ponce, well, then you will have 15 days to answer. But as a matter of course, it's better to assume that you only have 10 days. Sometimes the fact that these pleadings are in Spanish for stateside employers or people who are not familiar with the Spanish language, they get it and they don't necessarily know what it says. They cannot recognize that it was filed under the summary proceedings of Act 2. So again, it is important that you prepare yourself to be able to forward expediently any kind of legal document or lawsuit that you get in Puerto Rico, so that you are able to answer it on time. Okay. In Puerto Rico, there is a constitutional right to privacy which is applied against private parties. This has created a substantial case law as to how that plays out in the workforce in terms of email oversight and surveillance, and particularly in the case of use of video cameras in the workplace. There is nothing illegal about having video cameras in the workplace. Again, you just need to make sure that you have all your procedures in place and that you comply with the notice requirements that were established by the Puerto Rico Supreme Court, so that your employees are aware that there will be video surveillance. It's similar in the case of emails and telephone use. Just make sure that your employees are on notice that there is no expectation of privacy in their use of emails and computers, because you as the employer reserve the right to review them for purposes of performance, etc. Make sure that your policies establish that, so that you don't run into a constitutional claim later down the road. And that, in fact, you're able to use these in order to establish just cause in the event of an Act 8 claim. Retaliation, I included this here because Puerto Rico's whistleblowing statute is a little broader than what you might be used to seeing with respect to Title VII.